a couple things I want to clear up for the record. He talks about the November 2015 hearing in front of Judge Skeen over the executive sessions. Just so everybody understands, when he sent out a subpoena for the executive sessions, all the county wanted was a court order. Because what happens then, the county complies with that, and you have individuals out here that go, wait a minute, that's a Class A misdemeanor. So all they wanted was the protection of a court order. If Mr. Brody had come and said, hey, can we just go to the court and get an order? That would have been
Why
fine.
don't we do that now? Why don't y'all just get
Fine.
together and say, hey, can we go to the court?
Happy to,
Narrow
Judge.
this down to what we really need?
Happy to. I mean, the whole point of it is no one's trying to, and one other thing, Judge, because I don't want it to be out there where, and I want people to understand that the public information request from Joanne Fleming, I don't know to what extent we were involved in getting that, but we handled those. But what was given to him when he says, I didn't get all the emails in the ATSOL, that was Karen Phillips. We have no part in that. So the whole point of it is.
I've got a document, I believe from her, she's the county clerk.
Right.
It said that she does not deal with these, that it's the
We don't.
administrator that technical.
We don't. I mean, the whole point I've talked to, I can tell you I don't. I've never seen emails, I've never had possession of them. And talking to Thomas, two of my ADAs that handle this, they've not had possession of the emails. And Don Bell, I can call him as a witness and confirm that, or looked at them. So that I guess are the subject of this last request. So all we're trying to say, Judge, is we are involved in this, the DA's office is, because we have recused ourselves off the criminal matter. But under Article 44 of the Texas Government Code, if they request us to be involved, it says we shall. So we have to be here. They have a privilege that they are exerting, attorney-client privilege. Additionally, we have like Mr. Barber and Wilson, who are department heads and elected officials that are concerned because of those 150,000 emails. Part of what's contained in there is protected health information.
Why would that be anything that has to do
Because-
with contract?
Because the subpoena that was sent out by the AG's office covered every email that had been sent in a 1-year period of time from multiple county
What would you
officials.
suggest that be done to narrow this down to emails that are relevant?
We understand Mr. Brody has a case to try. And we understand that he wants stuff relevant to the Open Meetings Act, or violation of the Open Meetings Act, and communications between ATS and other officials.
And I think the state has a duty to produce that.
Happy to. I mean, if the court, see, the thing about it is, we have an ethical duty under the government code 44 to represent our client. I mean, we're here because the government code says you have to be. And they have exerted a privilege that we then have to be here and defend on behalf of our client. One of the things that allows those things to be disclosed is a court order. If the court determines that, hey, this is something he's entitled to. We are happy to narrow down the scope and narrow it down. And if we think there's something that the court needs to look at and make that decision, give the court an in-camera hearing on 10 or 15 emails.
I gotta say, I can't review
Of course
150,000
not.
emails.
And we can't, and the part of the problem, Judge, is that when you go to the Federal Health Insurance Portability and Accountability Act, HIPAA, which is a federal law that carries criminal penalties, we can't hand over as a third.
I don't see any reason for the county to be handing over documents that are irrelevant and pertain to people's private and personal business, like their insurance and their claims and et cetera, et cetera. I mean, that has no part in this, and I don't know why that's involved. Now, I will say this much. When you have a claim of privilege, you have to assert the privilege, and you have to say what it is you're asserting, and specifically. You can't just say, we've got attorney-client privilege to 150,000 emails. I mean, that just...
Well, we're not. We have narrowed that down, and we actually have those to something like 17 19 emails.
19 emails.
19 emails, Judge, so, and we're just asking the court essentially, to look at this thing, and if the court believes that he's entitled to it, and the court orders it, then that is something that it can be done. I mean, obviously that protects.
Are you saying you have identified the emails specifically that you're asserting a privilege?
Absolutely.
And how many are there?
19.
Just 19, that's all we're talking?
Yes, sir, because.
150,000?
Correct, but, go ahead. Yeah, that are related to ATS, which is all that's relevant. I mean, the problem is these 150,000 emails, Judge, include, the protected health information, social security information.
19 emails.
Okay, and if that's all and now I know, and I understand what Mr. Brody's gonna say is, well, how do we know it's only 19? I understand that.
Oh, you're only asserting a privilege to 19.
Right, to attorney-client privilege, but it's hard for us to go through 150,000 emails and pull out other information that county employees have a protected interest in. And that's the problem. I know Mr. Brody, and I understand, I really do, where he's coming from. But the problem is we can't just hand that over, then expose the county to lawsuits. We have Gary Barber back here, an elected official, who would have to turn over tax information with entities that have nothing to do with this. And that's the problem we have, is we are willing to sit down and work with the Attorney General's office in any way we can to narrow this scope, to give them anything they're entitled to. And if there's something that's a question, give 19 emails to this court and say, I mean, no one's trying to hide anything, but there is really a privilege.
Let me ask you, what exactly, okay, you told me as to the attorney-client privilege, you're only asserting as to 19 emails.
That's correct. Well, as to the ATS contract, there may be attorney-client communications that they would assert a privilege to, but have nothing to do with this. They could be other business not related to any of this. I mean, this is 1 year's
All right,
emails.
let me ask this. Is there a way to more specifically identify the relevant emails, such as, the contract, the name of the company, some other identifying information that could get us to relevant information and omit irrelevant information?
I'll let Mr. Stutes.
I'm sorry, who are you?
I'm Ronald Stutes. I'm an attorney with Cotter Minton Law Firm, and I've been asked by the county to help represent them in this matter. And the fact is, we could work with the AG on search terms. That's typically, we do lots of electronic discovery, where when you have 150,000 emails, without hiring someone to go through 150,000 emails, and the expense that would cause either by you, by me, or by the state, that we could then say, if it says ATS in it, that kind of thing, we would be willing to work with them on what search terms we could do, which would then bring that down to a universe of documents that could be examined to determine